Welcome to The Docket. I'm your host, Corey Snow. This is episode 10. After his indictment in Georgia for conspiring to overturn the 2020 presidential election, Mark Meadows asked a federal court to prevent his arrest and remove the case to federal jurisdiction, arguing he had immunity against the charges as a federal officer. In an order filed on August 23rd, a federal judge in the Northern District of Georgia flatly denied the request. What follows is an audio narration of the order the judge entered. Please note that to make it easier to listen to, legal citations have been omitted where possible, and footnotes are only read if they are relevant. A link to download the original document can be found in the description of this episode. The defendants in any criminal proceedings are presumed innocent until proven guilty in a court of law. In the United States District Court for the Northern District of Georgia, Atlanta Division. The State of Georgia v. Mark R. Meadows, Defendant. Civil Action File. Notice of Removal of Fulton County Superior Court, Indictment Number 23-SC188947. Order. This matter appears before the court on Defendant Mark Meadows' emergency motion for immediate removal or to prohibit his arrest. Having reviewed the motion and the Fulton County District Attorney's Office's response in opposition, the court denies Meadows' motion. Meadows seeks to stay his upcoming arrest on Friday, August 25, 2023. Meadows argues that his federal officer status and federal immunity defense protect him from being arrested and being brought to trial in state court. He further specifies that issuing a stay of the Fulton County proceedings, including his upcoming arrest, is consistent with and facilitates the purposes of these federal officer protections. Meadows urges the court to bypass the evidentiary hearing on his removal and assume federal jurisdiction over the case, with the understanding that the court then can reconsider such decision after the hearing previously scheduled occurs. Alternatively, Meadows requests the court to enter an injunction against District Attorney Fani Willis, enjoining her from executing Meadows' arrest until after the August 28th hearing. As the court indicated in its summary remand order, quote, the filing of a notice of removal of a criminal prosecution under Section 1455 shall not prevent the state court in which such prosecution is pending from proceeding further. End quote. Meadows cites two cases in support of his argument that the court can bypass the evidentiary hearing anticipated in Section 1455b5. Citing New York v. Tanella, 2003, and City of Jackson v. Jackson, 2002, the court finds neither citation to be persuasive. In Tanella, the parties consented to the facts alleged in the removal and agreed an evidentiary hearing was not necessary. Quote, both the state and defendant agree that no evidentiary hearing is necessary because there is no disagreement about the facts relevant to the court's determination of the removal issue. End quote. In this case, however, there is no similar agreement, and neither party has indicated that an evidentiary hearing is unneeded. Likewise, Jackson does not convince the court of Meadows' argument because, in that case, the district court did not mention the criminal removal procedures, let alone an evidentiary hearing. Such omission was appropriate, however, because federal removal had already been ordered, and the court was merely determining if the federal immunity defense would result in a dismissal of the criminal case. Here, conversely, the court has not yet made its determination on removal, and thus Jackson's persuasiveness is limited. Section 1455's statutory language makes clear that an evidentiary hearing is to be conducted once a summary remand order has been entered. 28 U.S.C. Section 1455b5. As Meadows' arguments and cases cited to the contrary are not persuasive, The court denies Meadows' request for the court to decide its jurisdiction over his criminal case before holding an evidentiary hearing. Meadows alternatively requests that the court enjoin District Attorney Fani Willlis from enforcing the arrest warrant against him until after the August 28th evidentiary hearing. The court denies this request. While Meadows' imminent arrest may present an actual injury, there are strong countervailing reasons to not enjoin the state criminal proceedings, e.g., abstention doctrines and principles of federalism. Section 1455 reinforces this conclusion by clearly requiring state criminal proceedings continue until the federal court has assumed jurisdiction and notified the state court. Indeed, in another case involving the removal of a criminal prosecution, a criminal defendant proceeded to trial even after a notice of removal had been filed pursuant to Section 1455. Thus, the court determines that the clear statutory language for removing a criminal prosecution does not support an injunction or temporary stay prohibiting District Attorney Willis's enforcement or execution of the arrest warrant against Meadows. For the foregoing reasons, the court denies Meadows' emergency motion. Footnote: Meadows furthermore suggests that, quote, the court could construe this motion as a petition for a writ of habeas corpus, end quote. The court declines to so construe Meadows' motion. It is so ordered this 23rd day of August, 2023. Signed, Honorable Steve C. Jones, United States District Judge. This concludes this episode of The Docket. I hope you enjoyed this audio version of Mark Meadows' motion to remove his case and prevent his arrest being denied. For updates on the docket, please visit docketpod.com or find us on Threads and Instagram as DocketPod. Please consider subscribing to the docket and supporting my Patreon at patreon.com/docketpod. Thank you.